appeal in the matter of Majid Ali and HSF Logistics Polska.
Thank you. So, Mr. Williams.
Yes, may it please your ladyship, your lordship, I appear on behalf of the appellant, who is the former claimant, and my learned friend, Mr. Stephen Turner, appears for the respondent. My lady, the claim for hire charges in this case was dismissed because the claimant was using his own vehicle without an MOT, which, as you are aware, is a criminal offence, albeit a relatively minor one. The appellant says that shouldn't have happened, both on a narrow and case-specific ground, namely that the trial judge, Mr. Recorder Charman, had already ruled it would be disproportionate to take that relatively minor criminality into account when determining the civil claim, but also on the broader ground, at least in general, a failure to MOT a vehicle should not impeach a civil claim. And we submit that the law has decisively set its face against minor motoring offences having such an effect, even where the unlawful behaviour in question has had a decisive causative impact on the relevant loss, which of course is not this case. And we give the example in our skeleton of the failure to wear a seatbelt. That is a criminal offence. In many cases, the commission of that offence has led to a claimant suffering personal injuries he would have entirely avoided. And yet the law's response is not to say the claim is forbidden by the imposition of the illegal act into the chain of causation, but to impose a deduction for contributory negligence. So in other words, the law has regard to the claimant's lack of self-care, but it does not have regard to his or her unlawful conduct in a motoring context.
Mr. Williams, I just wonder if at this point I should indicate that the court has had the opportunity, obviously, to read
yes.
the judgments.
Yes.
We've had regard to the skeleton arguments, and you've touched already upon the criminal offence.
Yes.
It would assist the court greatly at the conclusion of the case, no doubt, because I'm not expecting you to do it in short adjournments or otherwise, to receive an agreed note as to seizure of the relevant motor car. It's pursuant to 165 of the Road Traffic Act 1988 and the 2005 regulations for a car that was being driven without a valid certificate of insurance. So that is one that could not be invalidated.
Yes.
But that's in due course.
Yes, I'm grateful, and Mr. Turner and I will obviously put our heads together on that and revert to you as soon as we possibly can.
Thank you very much.
Thank you. So I think I just given the example of a seatbelt, and as we also said in our skeleton, the reality is in motor claims, running down claims as we used to call them, the commission of small, and I don't mean that term in any belittling sense, people obviously should comply with the criminal law, but the commission of small criminal offences will be legion. As I say, in any split liability case, because of the indistinguishability of the test for the criminal offence of careless driving and the civil standard of negligence, the claimant who has contributed to the accident will have almost certainly have commissioned the careless driving offence.
Well, you say it goes to the application or otherwise of ex terpi, which has been resolved in your favour,
yes,
with no appeal against it.
Yes.
And you simply say, as I understand the position, that to assert that there's no causation is A, without proper foundation, and B, wrong.
My lord, yes. Yes, and of course, as in a sense, this and I know your lordship, of course, has professional experience in this rather vexed area. This appeal, in some ways, has miscarried and has become something of a phony war, because I doubt the court will have looked at our skeleton necessarily for the court below. But what we anticipated in that skeleton is that there would be a respondent's notice raising the ex terpi causa defence, which the recorder rejected, and so we would finally get a decision at a binding level of determination as to whether or not that defence is available in the context of minor motor offences. But of course that hasn't happened.
But you don't have to be very imaginative to think of a number of arguments which might have been raised, some of which there was an attempt to raise, which was ruled out because of the failure to plead it properly.
Yes.
But the issue we have to decide is whether that second part of Mr. Justice Martin Spencer's judgment correctly characterises the
Yes.
position in law.
Quite. I mean, it's really the simple question as to whether it is a distinct defence or whether I think below there was quite a lot of terminology around sort of people dressing up, but I mean whether it essentially is the illegality defence simply with a mask on.
I mean, it's really paragraph 16 onwards of his judgment.
My
isn't
lady,
it?
it is, yes.
It's where, in that final paragraph of 17, he's suggesting it's not ex terpi, but a different entity altogether.
Yes.
And then attempts to deal with Hewison. I mean, those are the two issues.
My lady, they are, yes, and respectfully, we say it's simply a mischaracterisation. It is the illegality defence, and Hewison shows that. And with the greatest of respect to the learned judge below, his treatment of Hewison is particularly unconvincing because, in essence, he says he agrees with the analysis of Judge Dean. But when you look at the analysis of Judge Dean has analysed it in a completely orthodox, as an orthodox instance of an illegality defence. And in Judge Dean's case, where the credit hire claim is disallowed because of a failure to insure, he does so quite explicitly on the basis of an ex terpi causa defence. And so the reasons which Mr. Justice Martin Spencer gives for finding that this is of an altogether different character in our respectful submission simply don't hold together. And
Well,
it
in
is
fairness to Mr. Turner, with immense tact and diplomacy, he does suggest that in respect of Hewison, the judge did muddy the analytical waters. It took a little courage, that one, Mr.
Yes.
Turner.
Yes.
Not easily done.
Well, it was done as deftly as anyone who's had the privilege of appearing against Mr. Turner, as I have over the years, would have expected. But it is perhaps telling.
Can I just raise one other thing? We all know that this is battle number 164 in the credit hire saga, which has been going on for any of us care to remember.
Quite.
But does the fact that it's credit hire make any difference in principle?
None at all.
That's what I thought.
None at all. Nor does the fact that in this case the charges allowed by the judge without any appeal by the defendant the judges he would have allowed.
Reasonable in duration and rate.
Obviously, my learned friend Skeleton puts me in mind of a composition by Philip Glass with the repeated emphasis upon £600 a day, and I can well understand why he does that as a prejudicial point. But legally, it's quite irrelevant whether it's £60 a day, £600 a day, even if it was £6,000 a day. So yes. If I can, because it goes to the causation, the so-called causation analysis, I will, if I may, just remind the court of the factual findings of the recorder, which are in the core bundle in paragraph 13, which begins at page 151. Obviously, the initial findings are that there wasn't an MOT and there hadn't been for 4.5 months.
Which paragraph?
This is paragraph 13, my lord, beginning paragraph 150. I'm so sorry, page 151, paragraph 13.
Thank you very much.
He begins with the absence of an MOT for 4.5 months, which he finds was due to a carelessness. Rather than something which was deliberate, but it obviously is the case that this claimant did have a poor driving record, and that was a part of the allegations against insurance fronting, which were disallowed because not pleaded. But the key findings in respect of the hire claim begin at letter K, which is over the page. His Honour finds at K the car is damaged and is unroadworthy. It was sufficiently damaged it needed to be recovered. Then at M, it was driven by Mr. Ali and his cousin regularly, both for business and in the evening for family and social purposes. The cousin used it during the day also for family purposes. So Mr. Ali did have a need for a replacement car when it was not available to be driven. And he didn't have an alternative vehicle. And in those circumstances, subject to the illegality and causation points, it's reasonable for him to hire a replacement. O, the replacement itself was reasonable. P, the period was reasonable. and R, this is Mr. Turner's £600 a day point. Because the defendant hadn't put in any evidence, the rate is deemed to be reasonable as well. So that is in fact a feature of this case, which has simply gone by default, because even though the law is in fact extremely undemanding of what it requires from defendants in this context, in this case the defendant didn't put in any evidence to discharge the burden it had of showing a failure to mitigate in respect of the higher rate. Those are the factual findings, and it's really against those factual findings I wanted to come to the recorder's findings on illegality and the separate issue supposedly of causation. So far as illegality is concerned, the discussion really begins at paragraph 15, but it begins with a debate about the quality of the pleading and such like. So I was going to jump directly to 26, if I might, which is at the first page 155. So where the recorder begins, I then turn to the law on ex turpi causa, which he says is long established. It's applicable to credit hire claims, which is hardly surprising. 27, then he cites the Patel and Mirza case and the now famous passage from the judgment of Lord Toulson for the majority, where he sets out the three criteria, of which the third criterion is the need for proportionality and a need to avoid overkill, and that's the word that Lord Toulson himself used. And then in terms of applying it to the facts, we really get that beginning at 37. And there was just one point I did want to notice, if I might, at 37, page 157. It's therefore necessary to go on to consider whether it would be proportionate to deny Mr. Ali's claim, which means the whole of his claim. And I was just going to pause there to note that forgive me, my lord, page 157,
Yes.
paragraph 37.
Thank you.
Where he refers to whether it would be proportionate to deny Mr. Ali's claim, which means the whole of his claim. Now, the reason I ask the court to notice is that seems to be the first appearance of a fallacy, which you get from the three judgments which I respectfully critique, namely this judgment, the judgment of Judge Letham, which this judge relies on, and so subsequently the judgment of Mr. Justice Martin Spencer, who all seem to be under the impression that an illegality defence can only impeach the entirety of a claim, which we respectfully say is wrong and is shown clearly to be wrong by Hewison. The reason I labour that slightly is, in my respectful submission, that perhaps begins to give you a key as to why the learned judges below appear to think they were dealing with something different from the illegality defence, because they think, oh, well, this can't be the illegality defence because it's only impeaching the claim for hire charges, and illegality is all or nothing. But for reasons I'll come on to, we respectfully say they're wrong about that, and maybe that has factored into what we say is this sort of taxonomic mistake, where they're wrongly taxonomizing something as causation. I'm sorry, Lord Justice Stuart-Smith looks horrified at my pomposity.
What's taxonomized? What does that mean?
Categorise. They yes, forgive me. They've wrongly mischaracterised something other than as an illegality defence, because they're attributing to the illegality defence a quality which we respectfully say it doesn't have. It's really, because there's no cross appeal, I won't labour the learned recorder's disposition of illegality, but essentially he finds that to disallow the claim on the basis of no MOT would be disproportionate, applying the third of Lord Toulson's criteria. As my lord has said, there hasn't been a respondent's notice reviving that point at any stage. So we then come to, obviously, the key to it, which is the point about causation, which is supposedly separate. And if I can take that up at paragraph 48, which is at page 159. So that's a summary of Mr. Cheetham, who's Mr. Turner's predecessor. It's a summary of his submission. It's not possible at the time of the accident for Mr. Ali lawfully to drive. Therefore, it was not a reasonable act of mitigation for him to hire a replacement vehicle. In substance, he had no loss of use claim because he did not have a vehicle which he could lawfully use on the road. Mr. Ali was not entitled to be put in the position of having a car which he could legally use on the road while his car was being repaired, because he could not legally use his car on the road at the time of the accident. I simply pause to say that even as Mr. Cheatham's point is articulated, the question of legality is iterated 3 times as being at the heart of that submission. And in my respectful submission, that's a somewhat inauspicious starting point for the proposition that this argument is completely different in character from an illegality defence. But the essence of Mr. Cheatham's argument, which is maintained, is really 2 steps. Step 1, he has no loss of use claim because he doesn't have a car he can lawfully use. And then step 2, therefore incurring the higher charges was an unreasonable act of mitigation. Now, I would in fact suggest that Mr. Cheatham didn't really need to bifurcate matters into 2 steps like that, because the first step is really all that matters. If there is no loss of use claim, then there clearly is no higher claim. The one is parasitic on the other. So the real question is there a loss of use claim? And so in my respectful submission, what it reduces to is were the judges below right to say that the claimant had no loss of use claim, and if so, why? And it's here in our respectful submission, A, that they go wrong, and B, you can see this isn't truly about causation. Because on the unimpeached factual findings of the recorder, which I've just reminded you of, the first impression must be the claimant had an obvious claim for loss of use because the defendant had damaged his car. The recorder finds that. He needed it for frequent use, as did his cousin. The recorder finds that. And he had no alternative vehicle. The recorder finds that. And he had an ongoing need to continue that use post-accident. And the recorder finds that. So but for the accident, the claimant would clearly have gone on using the vehicle which he was using before the accident. So everything at this point in the argument indicates a loss of use. And since there's a loss of use, then the claimant is indeed entitled to mitigate it by hiring. So in our respectful submission, for this argument of the defendant to leave the traps, as it were, there has to be some obstacle to the fact that on the recorder's findings, the claimant seemingly had a loss of use claim that was unanswerable. So what is the obstacle to that otherwise unanswerable claim? And in our submission, the only obstacle one can identify, and in fairness to Mr. Cheatham, he puts it bang at the centre of his submissions, is your use entailed a criminal offence, and therefore you cannot, as a matter of law, be compensated for the relevant head of loss. That is the rock on which Mr. Cheatham argues the loss of use claim founders. That is the argument the recorder accepts, and in our respectful submission, that is manifestly an illegality.
Mr. Williams, you're going quite fast.
Forgive me.
Use entailed a criminal offence, and therefore, as a matter of criminal law, you cannot be compensated, or as a matter of civil law?
As a matter of civil law.
Thank you.
Forgive me. It's a fault of mine, I know. To gabble.
No, it's me being slow, I'm sure. The
He didn't say gavel, he said you were going too fast. Wait, no, you didn't. You said you were going too fast.
Okay, thank you.
Thank you. Yes, so that's why we respectfully say that this is just the illegality defence, as I put it, with a mask on, because really the sequence, the only rock, if I can muddle my metaphors, on which the loss of use claim can founder is the proposition that you cannot sustain that claim in tort because your use of the car pre-accident entailed the commission of the criminal offence of driving without an MOT, of using your car without an MOT. Because in our submission, the factual cause of the claimant's loss of use was clearly the damage sustained by his vehicle in the accident. But for the accident, he had gone on using it. So the bar to him being compensated is the criminal conduct of using the car without an MOT. And respectfully, we do say that that is essentially recognised by Mr. Justice Martin Spencer. Obviously, one understands why forensically my learned friend had to say in the very candid passage in his skeleton to which the court has adverted, forensically he had to say that Mr. Justice Martin Spencer's reworking of the recorder's analysis was unnecessary or unhelpful. But in our respectful submission, it isn't that at all. What Mr. Justice Martin Spencer is revealing is precisely what actually happened. This was an illegality analysis, which of course then leads to the separate question I'll come to when I come to his lordship's judgment as to whether or not his categorisation of the two types of illegality was a sustainable one.
Before we get there, can we just be absolutely clear, or could you clear my mind as to how the tortious analysis works? You've got a claimant who, as a matter of fact, needs to get to work.
Yes.
And that is the claimant as the defendant finds him.
Yes.
You drive into his car. It's reasonably foreseeable, clearly, that he will be using his car to get to work.
Yes.
But loss of use claims are frequently referred to as a sort of crystallization or turning into a liquidated claim of what exactly? Loss of. I think loss of use or a need.
It's the higher claim that has been referred to as a liquidation of the loss of use claim, my lord. Right. I think that might be what your lordship's thinking of.
The loss of use. If one fixates on the loss of use, one's in danger of simply looking at the car, which is dealt with in the tortious analysis by saying it's reasonably foreseeable that if you
yes.
The loss of use claim is simply a function of the claimant's need, the claimant whose chattel you've damaged. So if you analyze it like that, the question is whether the claimant's need, which has got nothing illegal about it at all, is to be compensated. I'm being a bit slow, but the reason why I'm pursuing it is that there may be a danger in just using the labels loss of use, because that concentrates excessively on the car, the Volvo.
Yes.
Okay.
So, I mean, if it's...
But you're not telling me I've got something...
No, I mean, if it's of any assistance, and I appreciate this may mean more to your lordship than to their ladyships, but if you throw your mind back to a case we don't have in the bundle, but you'll know is the origin of so much of this Diamond and Lovell, there's a very careful concurring speech by Lord Hobhouse at the end where he does rather delve into the way in which these cases can be analysed. And as I recall, and it may be if we're putting in a note afterwards, if it would help the court, we could include a copy of Diamond so you could just refresh your memory of the Hobhouse analysis, if I can call it that. As he says, at a point a chattel is damaged, it suffers a diminution in value, which is a capital account loss. But the law also recognises the right to be compensated for its loss of use. And that by default gives rise to a claim for general damages, for which the courts in essence allow a sort of solatium, which they often assess with regard to the amount of inconvenience, or if I think it's the word Lord Hobhouse uses, the hassle a claimant is put to by being deprived of their vehicle. One doesn't imagine Lord Hobhouse saying the word hassle, so it's a memorable speech for that reason as well. And then if you go off and hire a car, the analysis is that then becomes a claim for substituted damage, a claim for special damages for the substituted expense that you've incurred to mitigate the loss of use. So that's how it's been analysed in the authorities, and I think it's that substituted expense which your lordship had in mind, where the judges have referred to that crystallising the loss of use. And I think we do actually have some of that reiterated in the sequel to Diamond in the House of Lords, which is Langdon, which we do have in the bundle. And over the shorter German, Mr. Turner and I can remind ourselves as to whether there's anything in Langdon that will help you on that as well. Going back to yes, I would think what I was saying was I've just made the submission that looking at the recorder's judgment and the argument for Mr. Cheetham he was accepting, that in essence is the acceptance of an illegality argument. And I went on to say that to some extent that is in my submission vindicated by the fact that Mr. Justice Martin Spencer essentially reformulates the analysis in the way that Mr. Turner respectfully criticises. If I can then come just before I leave the recorder to his actual disposition of this argument, which is we know he accepts. At paragraph 50, so this is page 159. He records that my predecessor, Mr. Bartlett, says that this is just causation. Causation is just illegality in disguise. I disagree. The causation defence is, in my judgment, a distinct defence, which is capable of applying only to the credit hire element of the claim, because it's based on the distinct nature of the credit hire claim. Can I pause there to say, in my submission, one here sees again the fallacy that this must be something different from illegality because it's capable of applying only to the hire element. Goes back to the respectful critique I made earlier, that the judge, in line with Mr. Justice Martin Spencer and Judge Letham, seems to think the classic illegality defence is all or nothing. So we've got that again here. No, this is different because it's capable of applying only to the credit hire element, and that we say is wrong. Then at 51, he says the most fundamental point is in order for the issue of mitigation to arise as higher, it's necessary for the claimant to have a loss of use claim in the first place. If immediately before the accident, a claimant does not have a vehicle which they were entitled to use on the road, they cannot claim for the loss of use of such a vehicle because they have no such loss. Now, that's perhaps the key passage. And in my respectful submission, although the judge doesn't quite use the terminology, you do very clearly there again see the illegality defence. He isn't actually saying the claimant did not suffer a loss of use. He is saying the claimant does not have a vehicle they're entitled to use. And then he says they cannot claim for the loss of use of such a vehicle. Now, my lady, I asked rhetorically, why on this judge's analysis can't this claimant, who on all his factual findings had an open and shut case of being entitled to hire a car, why can't he claim that? And the only available answer is because of the illegality of the pre-accident usage. And so in my respectful submission, that does expose that this is an illegality defence in a mask. And when the recorder says in the next paragraph, this is entirely legally distinct from the illegality defence, then in our respectful submission, that is simply a mistake. And so, and again, just to conclude his reasoning, which is at 58, the other sort of key dispositive passage. In my judgment, Mr. Ali's credit hire claim fails because he has no loss of use claim by reason of not having a vehicle which he was entitled to use on the public highway at the time of the accident by the reason of the absence of an MOT certificate. And he's not established he could and would have obtained a valid certificate at any time during the hire period. He therefore has no claim for loss of use, and so he didn't need to incur the hire charges. Again, I asked the rhetorical question, well, why doesn't he have a loss of use claim? And in my respectful submission, the answer is obvious. The only available answer is because of illegality. On all the judge's other findings, he had an unanswerable loss of use claim. The judge specifically holds he was reasonable hiring a replacement vehicle, and he did so at a reasonable rate and for a reasonable period. So it's all, in my respectful submission, it is all about illegality. Can I, before I come to the Hewison case, just deal briefly with the offence itself? because it obviously is part of my submission without in any sense wishing to minimise the importance of MOTs, but it is, of course, part of my submission. And I'm less subdued in making it by the fact in some ways it's what the recorder found in finding it would be disproportionate to apply an ex turpi causa defence, that this is a relatively minor offence. And just therefore for the record, the offence is created by section 47 of the Road Traffic Act 1988, which the court has in the authority bundle at page 388. I am using electronic bundle, so let me just get the tab number for those who aren't. It's tab 15. So it's the foot of page 388, section 47, obligatory test certificates. A person who uses on a road at any time a motor vehicle to which this section applies, and as respects which no test certificate has been issued within the appropriate period before that time, is guilty of an offence. Now, I don't suggest it's a conclusive point. I don't remotely suggest it's a conclusive point. But I did here also want to notice that in this part of the Act, it doesn't actually expressly say the car mustn't be used. It simply says if you do use it, you've committed an offence. And that is in distinction from other parts of the Act. We don't have it in the bundle. So again, if we're putting on it in a note in section 165, I can append it to that note. But for example, section 143, which is the compulsory insurance obligation, section 143 does provide a person must not use a motor vehicle on a road or other public place unless there is in force such a policy of insurance as complies with the requirements of this Act.
And that's your problem, isn't it, Mr. Williams? Or not your problem, a problem, in the sense that failing to have an MOT certificate means that the insurance certificate would be invalidated.
Well, that is not an entirely easy question. First of all,
I'm asking it
yeah.
because I really would like to know
Yes.
the answer.
Well, the answer is that in the court, so far as the findings were concerned, the insurance policy wasn't in evidence. The judge took, the recorder, I mean by the judge, said he took judicial notice of the fact that some insurance policies may contain such a provision. But he certainly, there's no finding that they generally do. The other difficulty is that although a failure to have an MOT might give rise to a contractual defence by the insurer to any claim by the insured on the policy, it is to put it at its lowest, it is highly unclear as to whether or not that in fact invalidates the insurance policy vis-a-vis any third party so as to throw the claim on the MIB.
But, you would say in any event that was not before the court. That was not the issue that the court decided.
Right.
But as I indicated to you at the outset, it does lead to the possibility of the vehicle being seized.
Yes.
Which is why we would
Yes.
be assisted by that
Yes, indeed.
agreed note, if we may.
Yeah, of course. And I think one of the points I make in my skeleton is to say that seizure of a vehicle or disqualification from driving, that those are sanctions the criminal law imposes. And if the MOT offence was subject to such sanctions, then one could well see an argument that it would be inconsistent with the criminal law for the civil law to allow somebody to go off and hire a car. But that, A, that isn't this case, and B, even if it was this case, the recorder finding the ex turpi causa defence was not engaged hasn't been appealed.
Yes, it doesn't necessarily just go to ex turpi causa, though, does it? If the car was at risk of being seized at any moment, that is the car that Mr. Ali was using, then there are consequent arguments which haven't been put forward, but there are consequent arguments relating to whether or not somebody is benefiting more greatly than they deserve. I'm not going to use the words because it's not before us and I don't want to set any hairs running.
No.
But you see the point.
My lady, I do, and if I can respectfully say so, if ever there's an arena where you wish to be very cautious about releasing hairs, it's this one, because I have to say I suspect my Lord Justice Stuart-Smith was out by several decimal places, but by several decimal powers as to which point we're now on in this litigation. I suspect we're well into the thousands rather than the hundreds.
Yes, and your warning to us would be keep to the what's at issue in this case.
Well, anyone who is laboured in this field, and obviously I'm aware that, albeit at a far more august level, my Lord briefly once did so, will know that.
Don't overdo it, Mr.
Well, will know that. I mean, for example, it isn't fanciful, whatever my learned friend may say, in his skeleton, for our skeleton to say, if this minor criminal offence is enough to invalidate a hire claim, then having a licence plate, a registration plate in the wrong font, or some defect, one of your front lights not working, or something of that sort.
That's why I
that
think
will
you
be
need to
seized
look
on.
at seizure rather than offence.
Yes.
Okay.
Yeah, and that's also why I'm perhaps unnecessarily, given that the HSF character finding hasn't been subject to an appeal. That's also why I am labouring my point that the points that I am making are localised to the MOT offence, which is, even by the standards of motoring offences, a very modest offence because it's non-endorsable. I make the point in my skeleton that it's almost invariably dealt with by a fixed penalty.
Mandatory fine, isn't it?
£100 fine. As I understand it, I think we've got this in a footnote in our skeleton. It's almost an administrative process because the DVLA's computers flag people that don't have MOTs, and the DVLA can issue fixed penalty fines that they don't have to be issued by the police. So it's at an administrative level, but it is particularly significant, perhaps even more than the fact it's fixed penalty, that it's non-endorsable. So in contrast again to driving without insurance, you can't have your license endorsed, and you can't be disqualified for this offence. So from that perspective, it is really right at the bottom. If
Well, that depends on its impact on Section 143, on the facts of the case,
Yes.
and the facts of the insurance
Yes.
certificate. And of course, one can also see that the facts relating to no MOT in any one civil case may vary completely, because there are some no MOTs because the case in point really does reflect that the car is very dangerous.
Yeah, well, indeed.
Or undrivable.
Absolutely.
So the factual issues.
Yes.
It's not just the no MOT, and you pointed to the findings that the judge or the recorder came to, that this was a drivable car.
Yes.
Yeah.
Yes, and certainly, again, as we say in our skeleton, we well recognise that if you actually have a defect, particularly one that makes the car dangerous, first of all, that opens the door to some much more serious offences, some of which are imprisonable. But as your ladyship's just said, it's simply not this case. Again, I don't suggest this is the litmus paper, but just out of my own curiosity, I had to look overnight at whether or not a conviction for this offence is something which a practising barrister or a serving judge has a duty to self-report to their relevant regulator, and the answer is in neither case is it something which gives rise to a reporting obligation, even for a judge.
I don't think that helps your argument either
well,
way.
I'm simply showing that.
But what it might do is raise issues of utmost good faith when you're applying for an insurance of certificate for your motor. So if you have been criminally prosecuted, or you can only be criminally prosecuted, if you have been prosecuted for the offence of driving without an MOT certificate, even if you've been issued a fixed penalty, there may be an obligation. But we're going off into factual scenarios that don't apply here.
Well, my lady, that's a very fair correction, if I may say so. But just since you mentioned, I think it's probably true to say that nowadays there'll be others in court that know more about this than me. But I think if you don't have an MOT certificate at the point you buy your insurance, you won't be able to buy insurance because the computer systems are just tied up to the DVLA database. It's like when
That's why fronting may happen, but we're not concerned with that either, are we?
We're not.
No,
thankfully. And I certainly don't take any issue with my learned friend skeleton, where he says if that pleading point hadn't been taken and there had been a finding against my client, then this case would look very different.
Well, you might not be here.
I So it's against this background that we say the recorder was right to find that there was no conventional illegality defence, giving the disproportionate overkill elements of Patel. I can take the court to Patel. I have to say in my note I was planning to, but I have the sense that I'm being moved along, and I appreciate there's not, and that's not a complaint. I won't, in circumstances where the recorder's Patel analysis isn't impeached, then I'm happy not to take the court.
Mr. Turner isn't impeaching it.
So I won't take the court to Patel unless I need to.
Mr. Turner, he makes clear in his skeleton that you're over. I think Mr. Turner is saying you're overdoing
I'm
the
over
illegality
elaborating.
point.
Yes,
Yeah.
absolutely. I'm again once more well rebuked. What I then would simply say that in the previous cases, there has been, in fact, a consistent recognition also that minor motoring offences are not sufficient generally to engage an illegality defence.
That's Lord Justice Elias.
That Lord Justice Elias. Shall I just? Yes, it's the Joyce case. Page which is paragraph 51 of the Joyce case. So shall I just give it for the court's note? Paragraph 51, where Lord Justice Elias says that. And in the Velino case, that's the one of the prisoner who jumped out of a window. Paragraph 48, Lord Justice Sedley makes the same point about motoring cases. He's dissenting in the result, but not in the legal analysis. He makes the same point about motoring cases. And Sir Murray Stuart-Smith, at paragraph 70, says, and I appreciate that this might be a little bit too hard-edged, said in general it has to be an indictable offence. So I'm not, but you know, whether I don't need to go as far as to say that is some judge-created additional test, but I do nevertheless obviously say it's pretty indicative that an offence at the MOT level would not be sufficient. So the one case, if I might, that I wanted to spend a little time on, although not too much, is the Hewison case, which is at tab 2 in the authority bundle, page 22 for anybody using the digital bundle.
Sorry, can you give me that again?
My lady, yes, it's Hewison, tab 2, page 22.
Thank you.
My lady, we say that this case is in fact very similar, and also does expose the, with respect, mistake of Mr. Justice Martin Spencer, who, having rightly reformulated matters in illegality terms, then says, but this is something different from a conventional illegality defence, because Hewison, we say, shows that it isn't. So why do we say Hewison is similar? We say that both cases involve a claimant claiming compensation for something he was doing pre-accident, that he would have gone on doing post-accident, but to do so would have entailed an offence. Obviously, in our case, it's driving the Volvo. But for the accident, before the accident, he was driving it. But for the accident, he'd have gone on driving it, and therefore he's entitled to be compensated for its deprivation, as crystallised, as my lord put it, into the higher charges. The Hewison case involves different facts. That is a claimant who, before the accident, was in lucrative employment as a maritime crane operator. As a result of the accident, he could no longer work in that capacity and was working as a debt collector instead, and so that led to a significant fall in his earnings. And his argument was, but for the accident, he'd have gone on working at sea. But the problem he encountered was that both before and after the accident, that involved the commission of an offence, because he dishonestly concealed the fact that he suffered from epilepsy and was on anticonvulsant medication. And it was on that basis that the Court of Appeal affirmed Mr. Justice Morland by a majority in finding that the claim failed. But they do so in our submission. Well, what I take from this case is firstly, this was a classic example of an illegality defence only going to one limb of a claim. It only went to the loss of earnings claim. The claimant was still compensated for everything else. In fact, it only went to the loss of earnings claim as calculated by reference to his earnings at sea. It appears he still got he was. So that was what that's where he failed. He failed to get loss of earnings with reference to his pre-accident employment because he was engaging in it illegally. Secondly, the analysis of the court is incomplete. The classical ex turpi causa terms, albeit Lord Justice Clarke, as he then was, whose Latin is obviously far better than mine, is able to tweak the tag in a way that makes it fit the case more precisely. And thirdly, all the members of the court are quite clear in saying that it was an important part of the analysis that the illegality in this case was significant. And they, in fact, all make the point that if it had been insignificant or collateral, then there would not have been a defence. So this case, in my respectful submission, really is the case that should have been dispositive of this case, leaving only the question of classification. Is this to be classified as minor illegality? Or is it to be classed as something more than that, in which case the defence would have succeeded?
Well, the way they put it is collateral or insignificant.
Yes, yes, indeed, my lady. Yes, yes. So I was using significant as the antonym of insignificant, but perhaps that would be a more faithful way of expressing it. Is the question of whether the legality was more than collateral or more than insignificant.
More than collateral.
More than collateral or more than insignificant. Yes. Well, my lady, I will take you to the passages. I said I'd be a little time on this, won't be very long, they're just a few passages.
Yeah.
But firstly, to contextualise it, I was going to take it up at paragraph 16, where you have Mr. Justice Morland's conclusion quoted. That's at page 27. So because this feeds into the subsequent issue of categorisation as to whether this is collateral or insignificant, and the majority finds it's not. So Mr. Justice Morland had concluded the claimant was guilty of deliberate and continuous deceit. On each medical examination, in answer to a specific question, he gave a positive lying answer. He repeatedly committed the criminal offence of obtaining a pecuniary advantage by deception, which is punishable by 5 years imprisonment. The gravity of his deceit is exemplified by the fact that ship owners require biennial medical examinations. A seaman who may have an epileptic attack is endangering the lives of others, particularly when operating a crane or a winch. I interpose to say this was a crane operator. He is putting at risk fellow crew members and dock workers and cable-laying divers. The claimant's situation aboard ship is wholly different from that of someone who has some physical disability or medical condition which will not foreseeably endanger anyone at his place of work. The claimant would never have been employed as an able-bodied seaman crane driver but for his criminal deceit. In my judgment, public policy does require me to declare that the claimant is not entitled to base any loss of earnings claim on the earnings that he would have had as a seaman, nor is he entitled to damages for loss of congenial seagoing career or a free board or lodging when aboard ship. So this has to be framed in my submission by the judge making very serious findings about the gravity of the claimant's misconduct. Second, I hope that makes good my point a few minutes ago that this is a targeted illegality, not even targeted on the loss of earnings claim, but on the loss of earnings claim simply as calculated with reference to a particular measure. I'm not entitled to base his loss of earnings claim on his seafaring earnings. And thirdly, that's explicitly a public policy analysis, which is the very thing Mr. Justice Martin Spencer says has no place in the recorder's treatment. But with respect to him, that really is, in my submission, impossible to reconcile with Hewison, although he attempts to so reconcile it. If I could then go forward to, still in the judgment of Lord Justice Clarke, to the Lord Justice's disposition, which I was going to take up at paragraph 27, which is on page 34. I'm using the bundle numbering, I should say, not the report numbering.
Yes, thank you.
So this is firstly analysis of what is the court dealing with here, and the court, the Lord Justice has just summarised some well-known pre-Patel illegality cases, and he says at 27, 3 lines down, middle of the page, it's common ground. He refers to ex turpi causa. It's common ground the maxim does not itself apply here because it's correctly agreed there is no principle of public policy which prevents the claimant from pursuing hhis cause of action for damages for negligence or breach of duty against the defendants. Forgive me, my lord. Paragraph 27.
Thank you.
I took it up 3 lines into the paragraph in the sentence beginning, it is common ground. So it's common ground that this isn't sort of classic ex turpi causa because no one's suggesting he can't get anything. The question is not whether he can recover at all, but whether he is debarred from recovering part of his alleged loss. However, as I see it, the principle is closely related. So I interpose there to say, again, we're diverging very quickly from Mr. Justice Martin Spencer, suggesting we're dealing with something which is quite different from ex turpi causa. It's common ground that there are cases in which public policy would prevent a claimant from recovering the whole of his damages, which but for the rule of public policy would otherwise have recovered. The principle can perhaps be stated as a variation of the maxim, so it reads ex turpi causa non oritur damnum, where the damnum is the loss which would have been recovered but for the relevant illegal or immoral act. A classic example is the principle that a person who makes his living from burglary cannot have damages assessed on the basis of what he would have earned from burglary but for the defendant's negligence. And then he says the authorities support such an approach. They support the proposition that where a claimant has to rely upon his or her own unlawful act in order to establish the whole or part of his claim, the claim will fail either wholly or in part. So all of this is recognising that the illegality defence, albeit with a slight tweak to the Latin, is not an all or nothing defence, and it can impeach just part of the defence, but that which is impeaching it, can impeach part of the claim, but that which is impeaching it is an illegality defence, it is not something different. And then in terms of his lordship's this issue about collateral or insignificance,
Just illegal or immoral.
Illegal or immoral. I suspect that in the 2020s, immoral has become a very, very unfashionable proposition. I think certainly the textbooks suggest. I think there's a note in Clark and Lindsall as to query the extent to which the old cases about immoral behaviour would necessarily be decided the same way now. But you obviously, ladyship, is right that that's the way it's put. I was then just going to trace into Lord Justice Clark's judgment the appearances of collateralness or insignificance that my Lady Justice Davies put to me. That makes its first appearance at paragraph 36, which is at page 37. There's a discussion at paragraph 36 of a passage in Kemp and Kemp on damages, and a previous statement of Lord Justice Hobhouse, which I don't think I need to invite you to. And Lord Justice Clark then comments, and this is adjacent to the marginal F, it is not, however, in my opinion, sufficient that the claimant has been party to some collateral or insignificant illegality or unlawful act. Thus, as Kemp puts it, a claimant is entitled to be compensated for his loss of earnings, even though in the past he's failed to disclose them to the revenue. And that again is why, with great respect to the judges below, this idea that it's an all or nothing matter is really quite difficult to understand where that came from, because any judge who has tried a personal injury case, and I suspect all of them will have done, will know it's absolutely routine when you're dealing with a self-employed person, for example.
Is it still the position on the authorities that if your earnings were from burglary, you don't recover? If your earnings were from a legitimate source but you didn't pay tax, you get the net of tax.
You get the net. Yes, obviously the court doesn't allow you to carry on sort of metaphorically avoiding tax, but you don't get disallowed, and that's what His Lordship just referred to. And that's why, as I say, with great respect to the judges, it's a puzzle that they think it's an all or nothing defence, because this is actually to judges in the county court and what would have been the Queen's Bench division trying personal injury cases. You might say in the case of a sort of self-employed people, it's sometimes as often as not. As to whether or not there was a complete disclosure of matters to the revenue in advance of the accident. And then the court then visits some Commonwealth authorities. And I'll just take this relatively quickly, if I may. But the reason I do it is because Lord Justice Clark goes on to say that these are examples of insignificant or collateral illegality. So at 39, paragraph 39, there's a reference to a case from New Zealand called Lebag. And what happened there was the claimant was a driver who was required to take a weekly rest day, but he didn't in fact do so. And the question was whether or not he could recover his asserted 7-day loss of earnings per week rather than 6 days per week. And the New Zealand Court of Appeal held that he could, and that is Lebag. And then at 42, this is the top of the next page, Lord Justice Clark refers to an Australian case from Victoria, by the look of it, called Mills and Batis. And that was where a man had a car repairing business which breached the relevant planning legislation in Victoria. And the defendant said that meant he couldn't recover the loss of earnings he sustained when he could no longer carry on that business. And that was rejected as well by the court in Victoria. And Lord Justice Clark then says, paragraph 43, where we have the sidelining, to my mind, both those cases are examples of what may be described as collateral or insignificant illegality. In my judgment, an English court should not deprive a claimant of part of the damages to which he would otherwise be entitled because of the defendant's negligence or breach of duty by reason only of some collateral illegality or unlawful acts.
So just cutting to it, are you saying that describes what has occurred in this case?
I'm suggesting that what has occurred today, in this case is insignificant. And allow me to caveat it in this way. Obviously, by definition, we are talking about illegality. So it is not me that is saying there is such a thing as insignificant illegality. That is something which the law itself recognises. And so I say once you accept there is a spectrum of illegal behaviour, then on any view, this illegal behaviour must be at the lowest end of the spectrum.
But in post-Patel language, you're saying that the illegality is not such as to require as a proportionate response
Quite.
to disallowance of a head of claim.
It would be an overkill, essentially, to achieve a position whereby a claimant who has a genuine need to have a car for his working and family life, as the judge found, can't replace it because he has commissioned an offence which the criminal law regards as something that's just dealt with by a basically administrative fixed penalty.
Take some of the sting out of this, if you say relatively minor.
Yes, well, I think on the whole I have been, but obviously here my lady put to me the word of the Court of Appeal itself, insignificant, and I do say it is insignificant precisely because that legal concept, which is not a concept that I've introduced, therefore by definition recognises there exists a spectrum. And however unpalatable the language might be, once there exists a spectrum, then this offence, in my submission, must be at the relatively insignificant end of it.
But you're not just talking about the offence itself, are you? But on the facts as found.
Yes.
It's important to recognise.
Yes. Well, precisely, because it was a case of carelessness. Again, I don't need to...
It is the carelessness that I'm concerned about. It's the fact that the court found that but for the lack of MOT certificate, the car was safe to drive.
Oh, yes, indeed. That's an important part of it as well.
If we were talking about, you know, a clapped out banger that could at any
Yes.
time have run into a pram, then you're talking about a different thing.
Yes, of course. I mean, and without being pedantic, of course, in those situations there would be other offences. So I'm not sure that I that's the reason I'm focusing on the offence, because that sort of carries with it the fact it's just that offence. But your ladyship is quite so to that extent. I think we're really saying the same thing, and I'm just perhaps using shorthand.
All right.
So it comes to this, does it, Mr. Williams, that in terms of the authorities, you're putting it firstly into the category of insignificant illegality within the meaning of Hewison, and then the third limb of Patel.
My lady, yes. And of course, on the third limb of Patel, in essence, I'm saying the recorder really has already found that.
Yes, he has.
Which one mustn't lose sight of, albeit that in many ways one's preference would be to decide the point on its merits rather than because of a sort of technical point about there not being a cross appeal. But obviously, if I have to resort to the technical point, then I'm anxious enough to win in order to do just that. But my lady, let me then just come lastly in Lord Justice Clark to his disposition, which is still on the same page, paragraph 45, where he sets out a series of findings having surveyed the law and the facts. He says, finding one, in order to recover his loss of earnings, he had to prove he'd go on working in the relevant capacity. Two, for him to do that, he'd needed to deceive his future employers by false representations. Three, he would thus have to commit the criminal offence of obtaining pecuniary advantage by deception, namely the opportunity to make the earnings, the loss of which he's claiming, which is contrary to the Theft Act. Four, while I accept the submission, the penalty imposed by a criminal court might not be severe absent an accident, that deception would, in my opinion, be neither collateral nor insignificant. It's not collateral, but it's central, because it's central to the proposition I would have gone on working in that capacity. My focus is on insignificance, not collateralness. Insignificance, it would not be insignificant because of the risks potentially involved to others if a seafarer should have the misfortune to have a seizure while working as, say, a crane operator. Some aspects of a seaman's work are inevitably potentially dangerous. That danger would be much increased if a seaman experienced a seizure at a crucial moment while, say, operating a crane. The judge quoted a passage from a statement made by Mr. Slainde, who was in effect their personnel manager, which included the following: seafaring is very hazardous. To conceal both his condition and his use of medication is very serious and dangerous, both to himself and to his colleagues. For example, if he had suffered a seizure while operating the crane during a seabed walk, there would have been dreadful consequences, even loss of life. Lord Justice Clark says, I agree with those views. Indeed, it seems to me that a ship owner or operator who employed a person in the claimant's position as a crane operator, knowing his history and condition, would be exposed to justified criticism and indeed potential liability if an accident were to ensue. And if I can just go down to Roman 9, adjacent to marginal G, he agrees, his lordship agrees with Mr. Justice Morland that the New Zealand case and the Australia case, so that's the town and country planning offence and the not taking a rest day offence, are distinguishable. In each of those cases, the unlawful activity was collateral or insignificant. It was not central as it is here. Now, I do say perhaps that's also telling, as I would suggest that both Lebag and Mills involved potentially, well, certainly Lebag, where he's not taking his rest day, which may be an important matter for a driver, is on the face of it something which appears considerably more serious than the present case. And I certainly do say the present case has nothing in common with the points that Lord Justice Clark had previously made at Roman 5 about the perils of working at sea. So my lady, my lord, my ladies, my lord, that's Lord Justice Clark. If I can just still, very briefly, with Lord Justice Tucky's short concurring judgment, taking it up at paragraph 50, which is at the foot of 41, page 41, where he concurs with Lord Justice Clark and shows that in answering this question, the courts were not, and then he cites the celebrated words of Lord Justice Bingham, which one finds cited in case after case. The court won't draw up its skirts and refuse all assistance if illegality is collateral or insignificant. And Lord Justice Ward, who dissents, he says in essence his judgment is explained by this. and in essence, it says that Lord Justice Ward is treating something as collateral insignificant, and to put it crudely, he disagrees with Lord Justice Ward on the facts. And Lord Justice Tuckey expresses his own view in the last sentence of paragraph 52, so by page 42, marginal G. This deceit was not therefore collateral, but essential to establish this part of the claim, and could not possibly be described as insignificant in view of the risks involved to the claimant, those with whom he would work, and his employers. So, my lady, that's my exposition of Hewison, which I do respect. I've already suggested why I say it's actually a very similar case. I also say it shows why there was absolutely no need for either the recorder or the judge to engage in the creative approach to what they labelled causation, because they seemed to think that illegality was all or nothing. The Hewison case showed very clearly it's perfectly possible to target illegality and to say there's an illegality objection to that aspect of your claim. But where, for the defendant on the findings in this case, the argument founders, is that, as the recorder actually found, but as in any event I submit, this does fall into the category of relatively insignificant wrongdoing, given the nature of the offence and the factual findings themselves, that it was careless, that it was, above all, that there was no evidence the vehicle was actually dangerous. So, my lady, can I, without going to each of the authorities in turn, because that, if I can borrow Lord Towson's phrase, might be overkill. But I would also say, as you would have seen from our skeleton, this is a road that has been travelled somewhat in the past. There are two decisions from Northern Ireland. There is the decision of Judge Dean that the judge mentions. I think in one of there's a decision of the senior civil judge in Newcastle, Judge Friedman. We've put them all in the bundle. But in all of those cases, the analysis is simply, does the illegality principle prevent recovery? Judge Dean, in a no insurance case, finds that it does. Mr. Justice Burgess in Northern Ireland, in a no insurance case, also finds that it does. Judge Friedman, who's the Newcastle judge in a no MOT case only, he finds that it doesn't. The Northern Irish district judge, who quite boldly, one might think, doesn't follow Mr. Justice Burgess in Northern Ireland, finds also no, it doesn't, because it's just no MOT. But all of those judges are analysing this as an illegality analysis. There's not a hint before Judge Letham and this recorder that causation really has got anything to do with it and is anything other than a distracted label, which, if I can respectfully say so, learned judges appear to have reached for because they misguidedly thought they can't apply a conventional illegality defence because it's all or nothing. But the decision of this court in Hewison explodes that proposition, quite apart from, as I say, it in fact being a common or garden situation because of the tax avoidance cases that I mentioned and my Lord Justice Stuart-Smith put to me a few moments ago. So, my lady, really, those are my submissions. I've obviously dealt with why I respectfully say the recorder is wrong. So far as His Lordship, Mr. Justice Martin Spencer, is concerned, the respectful critique I make of his judgment is perhaps pretty obvious, given what I've been saying as I've gone on, and it's also very clear from my skeleton. So I'll try, but obviously it would be remiss me not to conclude by going to His Lordship's judgment. So if I can. Just take that up. So it's a paragraph 16, which is at page 62 of the core bundle. Where his Lordship says it's about, he cites Judge Letham in the Ag Balaya case. He's concluded that this is about 5 lines down, that Judge Letham was correct, and the answer is that what we are considering are 2 different forms of illegality. And my respect for submission, Hewison shows that in fact we're not. There may be a difference in the effect, in that in some instances illegality may explode the whole of a claim. Classic example of somebody who's injured while burgling a house, for example. Absent exceptional circumstances, that person is likely to lose the whole of their case. But in other circumstances, exactly the same public policy principles are in play, and they lead to you losing just part of your case. And that's what this case was about. So we're not, in fact, dealing with different things. And to that extent, when we come to paragraph 17, and I think this is the passage that right at the outset, about an hour or so ago now, my Lady Justice Davies put to me as being really the nub of it, and I respectfully agreed. The learned judge says there 3 lines into paragraph 17, there's a second, more targeted form of illegality, which can be directed towards a particular aspect of the claim being made. This form of illegality does not involve considerations of public policy or proportionality. And we respectfully say that's simply wrong. See Hewison. Wrong both in that you need to resort to a different form of illegality, and wrong even if you do to think it is disconnected from the ordinary considerations of policy and proportionality. On the contrary, the analysis in Hewison is explicitly a policy analysis. And then as to then the learned judge refers at paragraph 19 to a slightly unhappy incident where his draft judgment hadn't referred to Hewison, though it had been referred to in argument. Actually, contrary to what the judge says at 19, it was referred to in argument. So I invited it to his attention. Happy to say he didn't think that I had overstepped the mark by doing so. But he goes on from 20 to explain why he departs, why it doesn't alter his conclusion. And he quotes Lord Justice Clarke at some length. And he says, the passage demonstrates in my judgment there is a form of illegality relating not to the whole action, but to the loss or damage claimed, and which is not the result of an application of public policy. Well, in my respect for submission, Hewison shows the opposite. And he completely fails to consider the points made in Hewison about insignificant or collateral illegality. And therefore how the demise of this claim can be reconciled with the unappealed finding of the learned recorder that this, in Patel terms, was a case of disproportionate illegality, using the post-Patel terminology. And he says it's but a small step to ally this form of illegality to the principles of causation. Well,
Give me again. Where exactly are
I'm
you?
still at the foot of paragraph 20, my lord. So just after the long indented quotation from Lord Justice Clarke.
Yep, got it.
And then he said it's but a small step to ally that to principles of causation. Well, to some extent, that is his lordship recognising that Hewison says nothing at all about causation. And doesn't analyse it in that way at all. And where he says it's but a small step to ally this form of illegality to principles of causation, well, in my submission, for the reasons I've already given, that's simply wrong. It doesn't have anything to do with causation. The cause of the claimant's loss of use was the accident. He clearly would have gone on, but for the accident, he'd have clearly continued having a car which he was using. The true objection is the public policy objection, and Hewison shows that public policy is indeed the right analysis. And therefore, on the unappealed finding of the recorder, but in any event, for the reasons I've attempted to advance independently, given the particular findings of the recorder and the nature of this specific offence, this was not a case where the illegality was enough either at an untargeted or targeted level to deny the claim which the recorder would otherwise have allowed. My lady, those are my submissions unless there are any points from the court.
Thank you very much. Thank you. So, Mr. Turner.
My lady, thank you. My lady, if I can go back to the fundamentals of this, which is the basics of credit hire claim. It's actually paragraph 27 of Langdon and O'Connor, which is tab 3 the authorities bundle, page 66, where you will see a very neat summary of the position. It's reproduced in my skeleton argument, but this is the source of the citation. And what that says is that hire claims are, by their nature, claims for your loss of use and inconvenience. They can be advanced as general damage claims. Loss of use claim would be a claim for general damages unless a claimant hires a vehicle. In that case, the general damage claim will convert to a claim for special damages. And that will be measured subject to a myriad of other arguments, but as a general principle, by reference to the reasonable cost of hire. But that proposition is qualified by the fact that a claimant can't recover damages for the cost of hire if it was unreasonable for the claimant to hire. And also, as a prerequisite to recovering damages for hire, the claimant has to show a need, which is why that was specifically dealt with by the Recorder. Now, the cases for that, the authorities, which we don't have in the bundle, but they're well known, and I suspect it's not in dispute between my learned friend and myself, are Giles and Thompson, House of Lords decision. You know, the comments of Lord Mustill, Giles and Thompson, and we can send those through if the bench wish to have a copy. And decision of this court, Singh and Yakubi. And what they say is the need to hire is not self-proving, that the claimant must show a need to hire, and that must be a reasonable need. So we have two fundamental requirements for the claimant to recover higher charges, or the appellant in this case. Must show that the loss of use has been sustained, and he must show that there was a need to hire such that hiring a substitute was a reasonable step to take in mitigation of loss. Now, in terms of what is meant by loss of use and inconvenience, the following case in the authorities bundle, Beechwood, Birmingham and Hoyer, again a decision of this court. That's tab 4.
I don't have tabs, so what's the
apologies,
number?
page 90.
Thank you.
Apologies for that.
No, not at all.
And
yeah.
This was a question of the proper measure of loss of use damages in a commercial context, but it raised and overlapped with general credit hire claims. The damages had been claimed by reference to the cost of hire, and the court had to decide whether or not that was the proper measure of loss. But paragraph 48, it's a decision of Smart Potter. The bottom of page 105. And I stress there that is not me.
I was going to say, I don't think you're old enough, are you?
I'm afraid I was involved in these sorts of cases then.
Oh, I'm sure, but
but
this Mr. Turner was obviously
it's the other Mr. Turner,
yeah.
shall I say? I suspect there are several, but Mr. Justice Turner, as he now is.
yes.
So we'll go back to paragraph 20, and there we see an exposition as to what is meant by loss of use and inconvenience, where we are dealing with a private vehicle. And it's from B downwards in the latter class being the private use by an individual. But the primary element of the award is that of compensation for non-pecuniary loss, i.e. the lack of advantage and inconvenience caused by not having the use of a car ready at hand and at all hours for personal and or family use.
So you're not talking about paragraph 20 of Beechwood, are you?
No, yes, I'm going back to paragraph 20. If we go back to paragraph 20, which it references, but that is a definition of what loss of use and inconvenience would
You
be.
were just reading from paragraph 48, weren't you?
When you were reading from in the latter class, that was paragraph.
Yes, that's paragraph 48.
Yeah.
Yes.
And
And
so
it's-
you've taken us back to paragraph 20.
Oh, sorry, I was still at 48. I was mentioning
Oh,
that Mr.
right.
Turner is mentioned. My error. Apologies for that.
Right.
We're in paragraph 48. We are dealing with the two classes of loss of use, the
Yeah.
commercial context and the non-commercial context. At B, this is page 106 of the bundle,
Yeah.
it begins in the latter class. And then we have there a statement of what is meant by loss of use and inconvenience. The lack of advantage and the inconvenience caused by not having a car. It's not ready at hand.
Yeah.
Now if we go back to paragraph 20, you'll see there the comments by Mr. Turner, as he then was, which are referred to. He makes the point that it's essentially a jury award when you're dealing with general damages. What would be considered reasonable compensation? That would be the situation you would be in if someone did not hire, or if the court found that it had been unreasonable for them to hire. So that's the legal framework. And the facts of this case are quite stark. This claimant had a vehicle with no MOT. The vehicle should not have been on the road. The vehicle was not legally usable on the road.
But that doesn't affect your client's duty of care to the owner of the vehicle, does it?
It doesn't know. I'm focusing on the vehicle, my lord.
Oh, there you are.
Yes. Doesn't affect the duty of care, but we have a vehicle which should not be on the road.
Should not be used on the road.
It shouldn't be on the road. Yes,
Is
the
that
offence
the
is used.
consequence of all those cases which say if you park the car, you're using your car?
I'd need to look
Which
into
I
that
haven't looked
point,
at for.
my lord. I'm thinking of road tax, perhaps, when you say it shouldn't be on the road, of course, because you'd have to do a SORN for
Well,
road tax.
But that's different.
Yes, I accept that. The offence is use. Section 45 of the Road Traffic Act 1988.
I think it would cover the situation, but assume it does for the point of your argument.
Yes. So
Use.
my argument is the respondent's argument. This car should not have been on the road, and I think if you talk to the layperson about a car without an MOT, they would say that car should not be on the road. Shouldn't be being used on the road. The accident then occurs. The vehicle sustains damage. Physical condition changes, and it's not drivable from that point onwards. Now, the appellant's position is that the absence of an MOT is irrelevant. The loss of the ability to use a vehicle without an MOT is the same as the loss of the ability to use a vehicle with an MOT. Same degree of loss of use, same loss, equally compensatable in the same amount. That's their position.
I think their position would be that's right so far as compensation is concerned, because the appropriate place for the criminal offence of having no MOT is for the prosecuting authorities. And it's for them. And it doesn't affect the overriding position.
Well, my lord, the respondent's position is that it does, because a car which cannot legally be used on the road does not have the same value in terms of usability as a car which cannot legally be used on the road.
Well, that's next week's case. Diminution in value shouldn't get all the repair costs because it wasn't MOT'd, but that's not this case.
Well, that's looking at a capital loss. I'm talking about it in terms of usability. In terms of usability of the vehicle, one can't equate a vehicle with no MOT with a vehicle with an MOT. And that's what the appellants do. They say it's exactly the same. The MOT is irrelevant. Now, as an illustration of that, one point made in another one of the cases, Jack and Boris, it may be made in this case is, well, you can't go into the market if you have a car with no MOT and hire like for like, because you can't hire a car without an MOT. There are no cars that you can hire without an MOT. Well, that's correct. Because in terms of usability, legal usability, a car without an MOT has no value. There's no market for those cars.
Well,
So
there is. Scrap.
scrap, off-road
And-
use, private
and
roads.
I think there's a very, very prominent advert which is very, very prevalent on the TV at the moment concerning people who buy cars in any state with or without credit hire agreements on them or whatever.
Yes, but those adverts go to the capital value.
I see.
Looking here at usability.
Yeah.
And in terms of usability,
Capital value is a reflection of usability. Normally,
sorry, Mother.
capital value is a reflection or is affected by usability. So if you had a car which is completely undrivable, it couldn't, in a real sense, it can't be used, then its value plummets because it's a rust bucket or it's dangerous or.
Car without an MOT has less value. But I'm looking at the terms, the hire market. There's no hire market for cars without MOTs because in terms of usability, in practice, we're going to step back from the rarefied world of legal analysis to look at this in practical
But
terms.
in practical terms, what you're saying is that in terms of usability, Mr. Ali is asking to be put in a position different to that which he lost.
Yes.
So he wants to be put into a position by his hire of a car on the open market or from the open market that would mean he was driving legally and using the car legally rather than what he was doing, which was driving the car illegally. That's what you're saying.
Not quite, Ali. What we're saying is the focus should be on the usability of the vehicle, the quality of the vehicle, and not the use to which the individual
I think that's
wished
what
to put
I
the
think
vehicle.
we're agreeing violently there. I think what you're saying is that Mr. Ali suffered a capital loss by the damage to his car. His car was no longer drivable. When he then looks to mitigate that loss, his difficulty would be if he sought to put himself back in the same position, he wouldn't find the market because there's no hire firm that hires out cars that don't have an MOT.
Yes.
Therefore, you're saying he would be in a different position. He would be
Yes.
in a better position than he was before the accident
Yeah.
in terms of usability, legal usability, not drivability, usability. And you're saying use and drivable, usable, drivable should be seen in that context.
Yes.
Usable means legally usable, drivable means, yes, it was mechanically sound.
Yes.
Now, is that pleaded? Is that point pleaded in this case?
And that is the basis of the decision. There was an argument at trial as to whether or not the pleadings were sufficiently wide to allow that causation argument, and the judge found that they were, and the argument was allowed.
And
That
that first
hasn't been
instance or on the
That was
appeal?
a trial before the
Yeah.
recorder. There was an argument as to whether or not the causation argument, as it was termed, which is what this appeal's about, causation. There was an argument whether that was out with the pleadings. And the recorder found that it wasn't, and he permitted argument on that. Hence, we have the decision, and there was no appeal against that.
Right, okay.
So essentially, it's causation, because in terms of usability, the loss has already been sustained. By the time the accident happens, at the time the accident happens, the claimant doesn't have a legally usable vehicle. And so when the physical damage occurs in the accident, in terms of usability, it isn't adding anything to the loss that's already been sustained.
But he has a need,
Yes, but that's...
which albeit he shouldn't have been, he was meeting with his car. The effect of your tort was he couldn't do that. He had to go to the market.
Yes, but
So
Let's
then
see.
where's the causation argument?
well, need is the next stage, and he has to show that
That's
loss
how-
of a legally usable
But no,
asset first.
surely it's implicit in the recorder's finding that it was reasonable for him to hire the car, that he had a real need which he was unable to satisfy because you had damaged his car.
The recorder's finding is subject to the causation argument, expressly so, in that paragraph.
Yes, but it deals with the causation argument. Once you take his acceptance, as it seems to be at the moment, once you take his acceptance that the claimant needed to get to work, the argument is rather different from the argument you're putting forward, because you have prevented him. You have created a need for a means of getting to work. And that can only be done by hiring a car, or was reasonably done by hiring a car.
Well, that's...
The fact that then the question is there any mechanism for adjusting the recovery to reflect the fact, or the right to recover, but to reflect the fact that he was committing a criminal offence when he used his car? And the answer to that is to be found in extirpe. And the answer has been it would be disproportionate to deprive him of his damages simply because he was driving a car. He was meeting his need by driving a car which didn't have an MOT. So the recorder's findings, analysed in that way, arguably determine the case against you.
Analysed in that way, they might, but what I say,
What's
my
wrong
lord,
with
with the greatest respect, is that you're effectively one stage too far on in the analysis by looking at his need. He has to show that loss of use first, that he had a legally usable vehicle, which was then changed
But we start with
by the accident.
Sorry, I interrupt you. We start with this is a claim for general damages for inconvenience. He's got to get to work. That's his inconvenience. He can't do it. He doesn't have an alternative means of satisfying it because you've damaged his car. And you've damaged his car in circumstances which make it entirely foreseeable that you weren't to know that it wasn't an MOT car. Make it entirely foreseeable that he would have been using it for getting to work.
Yes.
That's, as I see it, the difficulty that you've got to face. I may be wrong.
The second stage, the mitigation stage, reasonableness of steps taken in mitigation, will address that concern. But I just make the point that car without an MOT, car with an MOT, not the same thing. There is a qualitative difference between them in terms of usability, and the respondent's position, as found by the judge and the recorder before him, is that the loss had already been sustained because there was no legally usable vehicle. And so there is no loss of use. But the alternative is to go one step further and then say, well, if there was a loss of use, what should the court say was a reasonable step taken in mitigation of loss? And the loss of use in reality here was the ability to use on private roads, off-road use, none of which the claimant says he did. So in reality, it was unreasonable of him then to mitigate that loss of use by going into the market and paying, and my learned friends mentioned the figure, I know it's a jury point, I know it doesn't affect the principals, but it's £600 a
We've
day.
done it 4 times already. You might as well do it a few more.
Well, I think, to be fair, my learned friend was the one who introduced the figure in oral submissions. I don't think I've mentioned it yet. But not a reasonable step to take in mitigation of loss to go out and hire a vehicle with an MOT when you don't have an MOT. And the reason it's unreasonable is because you shouldn't have been using the vehicle in the first place. The focus has to be on the value of the vehicle as an article. Its value in terms of usability is so diminished by not having an MOT that it's wrong in principle to equate that loss of use with the loss of use of a vehicle with an MOT.
Are you, I think you're running both. Are you running A, there's no loss because it was an unusable car, or whatever how you describe it. 2, if there was a loss, it wasn't reasonable mitigation to mitigate that loss by hiring a car with an MOT.
Yes.
That's a
now,
betterment argument. It's not a causation argument, it's a betterment argument, isn't it?
it is, yes. Now
Which is not the basis on which the judge found in your favour.
and I'm taking as the starting point for assessing reasonableness whether someone with a car without an MOT acts reasonably in hiring a car with an MOT.
Well, the logical answer to that is yes, outside this arena, because there is an encouragement for people to drive with an MOT. But you mean in terms of this case, which takes us back to my Lord's questions, which is you're running the 2 points that there was no loss because
Yes.
it's non-quantifiable on the open market. And if there was a loss, it wasn't reasonable, and my Lord puts this as betterment for Mr. Ali to claim betterment of position. And then my Lord's point becomes very relevant, which is, why wasn't this argued at appeal?
Betterment's not before us.
No, it isn't.
So
But-
you've got to hinge it on there being no loss.
Well, to the extent that there is a loss, it is the loss of the ability, the advantage of being able to use the car off-road and on private roads, which is no
Or-
loss at all.
It's the loss of the advantage of using a car which is drivable, but being at risk of prosecution for an offence, which is catered for by ex turpi.
Well, my lord, the difference is that in ex turpi causa we are focusing on the actions of the individual, whereas the respondent's analysis, my analysis, is what the court should do is focus on the chattel, the article, and how it is diminished by not having an MOT even before the accident occurs, to the point where it has no value in terms of usability, or alternatively, because that value is so low, it would be unreasonable to go out and hire a car with an MOT as a substitute.
Which is betterment, which wasn't pleaded.
Betterment wasn't pleaded, but it could be argued as a failure to mitigate as well, which I haven't gone back to the pleadings, but certainly there are findings in relation to mitigation. So it would come under the umbrella of mitigation. But
The
I
issue
accept-
we've got to decide, as my lady says, is was the judge right to say that there was no loss and therefore, notwithstanding the finding of ex turpi, there's nothing to compensate?
Well, the recorder did go on and say no loss and therefore hiring a car was not reasonable mitigation. That's in the recorder's judgment.
Yeah, but the premise for that is no loss.
Save for the nominal, effectively loss of being unable to drive on private roads and off-road.
But this is unreal, surely, forgive me. This is completely unreal. We're dealing with a situation which happens in real life. And yes, Mr. Ali can be criticised roundly for being careless and not having in mind, and he should have had an MOT. But if he'd been stopped by the police, what's the worst that would have happened? So the only thing that detracts from his ability to get to work is he might be stopped by the police, or he might be picked up by DVLC on APNR or something like that, in which case he's got a fixed penalty notice, boom, that's it. So it's the risk. If you're looking at what he has lost, never mind the morality or legality of it, he has lost the use of the car which he was using at a risk. I know no way of quantifying a reduction of damages on that basis, but
Well, the answer,
it's not this case. I think that we can happily say.
The answer, Mr. Turner,
the
you're going to say.
answer is that to lose something which shouldn't be on the road is no loss at all. But I've made that point, and you either with the respondent or not. I can only repeat myself in relation to that.
Remind me, please, Mr. Turner, did you appear at the first appeal?
No,
No.
this is
so-
my first
yeah.
involvement with the case. Now, if we turn to look at ex turpi causa, the phrase used was ex turpi causa in a different dress. But it isn't. The judge was correct to say this is a different entity altogether, and if we'll look at, he said in more detail in a moment, but a few illustrations of why, and I've made this point already, but it's worth repeating. In ex turpi causa, the focus will be on the individual, what they did or did not do, and there is inevitably an element of moral judgment. But here, the proper focus is on the article, the diminished value, in terms of usability, not capital value, of the article damage. Of course, pre-accident, post-accident, the respondent says that value is the same in terms of usability. Ex turpi causa would deal with losses which are established that would then be disallowed by application of effectively a supervening analysis. So these are losses which would otherwise be recovered, which are then disallowed for policy reasons. That is not this case. In this case, there was no loss of use because the usability of the vehicle had already been compromised. So that is why we are not dealing with ex turpi causa.
So why was ex turpi causa raised as a defence?
It was raised as an alternative defence. You can, I'm talking about this appeal, you can argue ride more than one horse in a case. On the same facts, you can plead a case or defend a case on mutually inconsistent arguments, if that is the way you wish to address and approach your case. The fact that the defendant rode two horses is neither here nor there, in my respectful submission. Maybe that the facts are, and will be in many cases, also susceptible to an ex turpi causa analysis. But that's not the case we're dealing with here. Here, we're dealing with a loss that didn't happen because of the diminished value in terms of usability of the article prior to the accident. Next, ex turpi causa requires high-level value judgments by the court, and then at the third stage of Patel and Mirza, proportionality to be brought into account. So there are policy considerations and proportionality as the defining factors of an ex turpi causa argument. Not here. Here, straightforward questions. Was there a loss of use? Was hiring a reasonable response to that loss of use? Proportionality has no part to play. Ex turpi causa is penal. It imposes a sanction for what used to be called moral turpitude, but certainly disapproval. That's not the position here. This claim failed on causation because the vehicle was already legally unusable. It did not fail as punishment for the claimant. And then we get to this point about all or nothing. The all or nothing approach, my learned friend termed it. And it's because it was said that ex turpi causa in the judgment isn't a knockout blow. Sorry, ex turpi causa is a knockout blow. This causation argument is different because it's not a knockout blow. So, my learned friend interprets that as there being a misunderstanding on the part of the tribunal below as to whether or not illegality would defeat everything, or whether it could relate to a specific head of loss as it did in Hewison. But that's not what the all or nothing comment refers to in the judgment. The judge below was well aware that
Is this Martin Spencer? Mr. Justice, Martin
if we
Spencer.
look at the recorder,
Yeah.
tab 2, oh, you don't have tabs, page 7 of the supplemental.
Sorry, can you give me a page, because I don't have tabs in this one either.
Page 7 of the
Page 7.
supplemental one.
Can you just hold on a second, please? Page 7.
Page 7, not the transcript page, but the actual page in the bundle and the supplemental bundle.
Well, I'm sorry, I'm looking at a bit of a transcript.
Yes. About
Page 7 of the bundle electronically generate, but 6 the internal page of the
yes,
transcript.
that's right.
Okay.
Lord, yes, and this is the exchange between Recorder Charman and Mr. Bartlett, Claimant's counsel at the original trial. And you'll see the exchange there beginning, but it turns out that Mr. Cheatham's illegality argument is correct. If it turns out that Mr. Cheatham's illegality argument is correct and I accept it, it does not follow that if I accept it for credit hire, that I also accept it for vehicle damage. And so it's clear that the recorder didn't see ex turpi causa as an all or nothing defence, meaning the whole of the claim has to go. And in Agbalaya, where the learned friend said there was an error there, in that the court saw ex turpi causa as an all or nothing defence, the vehicle damage and the personal injury were allowed, even though there was a finding of ex turpi causa. So that is page 367 of the authorities bundle. This is the decision of His Honour Judge Leatham. It's the one that the Recorder relied upon, and then Mr. Justice Martin Spencer in turn. And paragraphs 60 to 61 paragraph 60 is discussing ex turpi causa in relation to the credit hire claim. And you can see the final lines in that paragraph. So the hire claim would have been dismissed for ex turpi causa. But the PSLA, pain, suffering, loss of amenity for the injury, and the pre-accident value were allowed because the judge wasn't seeing ex turpi causa as all or nothing in the sense of the whole of the claim. What's meant by all or nothing is in relation to the individual head of loss. And that goes to the Jaguar example given by the judge. So the difference can be illustrated as follows. So the car with no MOT in a particular claim might have a claimant who can persuade the court that he would have had an MOT within a week.
I'm sorry, the person whose misunderstanding Mr. Williams concentrates on is Mr. Justice Martin Spencer, and he relies on paragraph 17.
Yes.
16 before we even get to 17. If you go into 16, where he refers to this judgment of Judge Latham, and then he says the first form is the one represented by the tag ex turpi causa, and then we have this. This is an all-encompassing defence which deprives a claimant of any form of redress. So whatever was said by other judges, that is what Mr. Justice Martin Spencer is saying.
He's talking in that context about any form of redress for that particular head of loss.
That doesn't
No, I'm not sure that's right.
If you then go to 7, either you go straight on to 16 or you go to 17, where you say, even if this is not, if there is not this all-embracing form of illegality which deprives the claimant of all claims arising from the accident, there's a second, more targeted form of illegality which can be directed to a particular aspect of the claim being made. Isn't it? And it's that feature, surely, which he says distinguishes it analytically from ex turpi causa.
My Lord, could I take you to page 62 of the core bundle, which is the transcript of the hearing before Mr. Justice Martin Spencer?
Oh, it's not the hearing. 62 is the judgment. The core bundle.
Yes, paragraph 16, sorry, it's 87.
87.
Yes, that's paragraph 16 and 17.
Let's be quite clear. You wouldn't support a submission that a difference between ex turpi causa and what you're contending for is that ex turpi causa is, as it were, a complete blunderbuss which demolishes the entirety of the claim, whereas what you're arguing for can be directed to individual heads of claim.
Yes, now ex turpi causa could be complete blunderbuss.
Could be, but does not have to be.
Doesn't have to be, and that's the ex turpi causa non oritur damnum phrase, which was referred to earlier on. So that's well established, and we see in Agbalaya that the personal injury and vehicle damage elements were allowed. And my lady, if you look at page 87, at the top of the page, we have Mr. Justice Martin Spencer talking about the two forms of illegality there. And that is what was meant by it being a different entity altogether.
I know you weren't involved below, but it's right, isn't it? No one suggested that because, to use slightly vernacular language, because the vehicle shouldn't have been on the road, there was no duty or no causation in relation to the damage or
No.
contrib or anything like that in
No.
relation to.
No. That wasn't suggested. So it's a different entity altogether, because with ex turpi causa, illegality is the reason for the disallowance. But with this causation argument, illegality is effectively part of the factual matrix. It affects the quality of the article when you assess the quality of the article and compare pre and post-accident usability.
So on your submission, Mr. Turner, the cases which have decided that the claimant who did not have an MOT prior to sustaining the loss of use could never succeed on a higher charge restitution. That's got to be right, hasn't it?
Yes. No, they don't have a
Regardless of
usable,
any
usable
facts,
vehicle.
whether it's carelessness or whatever,
Yes.
that would apply across the board.
But that's what brings us to the point at paragraph 16 to 17 of the judgment where the distinction is drawn.
Well, why draw the distinction at all? That's the question I'm asking.
Yes.
If your submission is right, if the fact that somebody was driving a car with no MOT prior to the accident means that what they've lost, whether through their own negligence or carelessness or deliberate flouting of the law, is not a loss at all, then why draw a distinction between those who've forgotten to renew their MOT?
The reason for that and the distinction that's drawn is because there are cases where a claimant without an MOT could persuade a judge that they would have had the car MOT'd had the accident not
Yes,
happened
but it
within
doesn't.
a few days.
Of course, but then I think the judge said, well, in that case, you don't claim for the few days that you were without an MOT, but you claim thereafter.
Yes.
But it undermines your argument, doesn't it? Because if you lost something that you were not entitled to use at the time of the accident, then why should you be in the position of making good that loss of use?
You don't make good the loss of use.
You do by MOTing your motor car on the basis that you persuade a judge that you would have done it if you'd been reminded of it. Or...
Yes. So then we look at the counterfactual, the but-for scenario. There's no loss to the point where the MOT would have been secured because you have this diminished article.
Well, you don't know if the MOT would have been secured.
Well, that would be a question of
I
fact
mean,
for
the
judge.
evidential aspect of this becomes difficult, doesn't it, on your argument?
Well, my lady, no, because in that case, if the claimant were going to run that, presumably they would have evidence that their car would, on balance of probabilities, have passed an MOT. It may only be 4 years old, for example, they're required from 3 years onwards.
Well, I mean,
They
it's
may have,
yeah.
apologies for speaking wrongly, but they may have evidence of a booking at an MOT centre. And there may be an engineering report saying prior to the accident, this car was in superb mechanical condition. That would be for the claimant to produce evidence to persuade the court that on the balance of probabilities, they would have had an MOT from, say, a week after the accident.
How does the engineer's report saying it's in superb condition affect the argument that they would or would not have had an MOT?
Well, if claimant had an engineer's report saying the tyres have a lot of life in them, and the engineer could look at this. If this was an issue in the case, the evidence would be tailored to go to that point.
Your issue is incredibly specific. You say if you didn't have an MOT, you might be able to prove that you would have got one the week after. That's what you were debating.
It's open to a claimant to do that, yes.
And all I was asking was, I don't understand how what you then said, which was you might have an engineer's report which says this is a superb car, plays into what you were talking about, which is you might persuade the judge that you were going to get an MOT the next week.
Yes, the appointment only takes it so far.
Because you've got to get
Because
the
you've
actual
got to
MOT.
persuade the judge that you will pass the MOT
Yes.
when you have that appointment.
So that's what the engineer's report
That's
would
where
go
the
to.
engineering evidence would come in.
Okay, got it.
Now, of course, if these points were pleaded, then the claimant obtaining evidence would no doubt include within the engineer's instruction consideration in relation to whether or not the vehicle would probably have passed an MOT. So it's an evidential point, and doesn't arise in this case. We didn't have that. But what it demonstrates is that when that distinction is being drawn between all or nothing, between ex turpi causa and the present scenario, it's not talking about all or nothing in relation to all heads of loss. We can see that because personal injury damages were allowed. It's talking about all or nothing in relation to this particular head of loss. If it was ex turpi causa, you wouldn't effectively be able to rescue yourself because there would be a moral judgment, a policy decision in relation to your conduct. But here, because the focus is on the condition, the legal usability of the vehicle, then the claimant could rescue themselves and effectively denude this argument of any force by saying, well, okay, you're right, I didn't have a vehicle I could legally use for 5 days, but I was planning to get it MOT'd at the end of the week, and here is the evidence of that. And then the judge finds on the balance of probability, this car would have been a legally usable car from X days after the accident. Therefore, I find that there's a loss of use from that date.
But you might also have a finding, or be at risk of a finding, that although it would be completely disproportionate for the claim to be thrown out on ex turpi causa, there was a failure. The judge is not satisfied, and that can take in all the features I'm about to mention. There was a failure to get an MOT, the person was careless, there was not, the judge court is not satisfied that they would have got the MOT at any stage during the 2 months or whatever it was, 6 weeks. And on your analysis, despite the fact of finding that it's disproportionate under ex turpi causa, you'd get rid of the case on this other basis.
Yes. And the reason for that
If it was
is
properly
that
pleaded.
ex turpi causa, sorry,
If it was properly pleaded.
if properly pleaded,
Yes.
and we'd have insurance considerations that would be brought into play.
Yeah, well, the pleadings are getting longer after today.
So, ex turpi causa is a different entity altogether.
Okay, can I ask you one other thing?
Yes.
The way that the offence for MOT, no MOT is set up appears from the authorities bundle, and it's you know the detail, and it ends up as is guilty of an offence, and then you can go on and find out what the sanction is. It's the same for a bald tire.
It
Does
is.
your argument apply? Well, at the moment, I can't see any difference between applying your argument to the MOT and applying your argument to a ball tire. Shouldn't be on the road if it had a ball tire. Anybody who drives the car is committing an offence. Or what's the difference?
The difference is that the MOT, notwithstanding the severity of the criminal sanction, is of greater significance than a bald tyre.
Why?
Because it's one of the threshold requirements that most people would recognise as having a legally usable car. Tax, insurance, MOT, the Holy Trinity, the absolute basics.
Your
that
answer,
you would
forgive me,
require.
your answer demonstrates, I'm sorry I'm interrupting you, I'll try not to. Your answer demonstrates that in fact the ball tire may be more significant, because as soon as you've got a ball tire, you've got a potential loss of control, so on and so forth, whereas less of an MOT with a superb car is of no real consequence at all.
Well, there are potential insurance consequences.
Okay. But
from
is
an
it,
MOT.
is your answer that your argument applies without modification to a ball tire?
No, my lord. Let me first distinguish the MOT. As I say, it's effectively a threshold requirement. It's one of, as I termed it in my skeleton argument, the Holy Trinity: tax, insurance, MOT. You can't tax a vehicle without an MOT. That's not the same as a bald tyre. You probably wouldn't be able to insure your vehicle without an MOT. So it's a fundamental requirement. Now, I look at the appellant's examples where they effectively say the court must be wary of a floodgates argument. If the court says this about MOTs, defendant insurers will be poring over vehicles, looking at the circumstances of the person's driving, and the courts will be inundated. Well, I counted 8. If we break down the examples given, driving too fast, failing to wear a seatbelt, parking illegally, using a phone whilst driving, they're not to do with the quality of the vehicle.
Would they invalidate the insurance certificate?
Careless driving.
Not so far as I'm aware.
So it would go to a different aspect of the claim.
They might, in another case, give rise to different arguments, contributory negligence.
Yes, but it wouldn't invalidate
The
the insurance certificate. So it wouldn't render it. So speaking on your phone during driving or not wearing a seatbelt, that's an offence. But you say it would not invalidate the insurance certificate, so you wouldn't be an ex turpy causer in any way. But I'm sorry to kind of cut across you, but one of the things that Mr. Williams asked, which is I'd like you to answer if you could, quite apart from the examples that he gives, but in his oral submissions, he made the point that having no MOT is a criminal offence, but that you are not, as it were, prevented from driving a car with no MOT, even though you do so illegally. It's just that you take the risk of a criminal conviction. Now, by extension, although you say about the hire car and not being equivalent, he has lost the ability, hasn't he, to drive the car with a risk.
Yes, but that isn't.
And then do you go back to the public policy, which then takes you back into ex
That
turpy
takes you to
causa?
ex-turpy causa, but my lady, what you're doing there is focusing on the individual, not the usability of the article. And it's loss of use and inconvenience. We're looking at how has the legal usability of the article been affected by the accident.
But you started your submissions quite rightly by pointing out that you convert the general damages of the loss of convenience for your own motor car and having it on the curb outside so you can get on into work without waiting at a bus stop, into special damages, which focuses on the individual, not on the chattel.
Well, it's the debt incurred by the individual when it's claimed for special damages because they sign a hire agreement.
Yes, but you convert your general damages into the special damages, which is your inconvenience, don't you?
But if you do that unreasonably, because you hadn't sustained a loss of use, save for the notional driving off-road, etc., then you lose the claim anyway. Because it was an unreasonable step taken in mitigation of loss.
So that's how you would distinguish Mr. Williams' argument on that point.
Yes.
Yeah,
And
that he's focusing on the individual rather than the chattel.
essentially, that's the overarching point here, and apologies for repeating it, but
No, it's my fault
Turpy
because I
Causa,
was slow in getting
you
it.
focus on the individual. This argument, you look at the diminished value in terms of usability of the chattel. And as a reflection of its diminished value, you look at what's available to hire. Nothing. Because these cars aren't usable legally, so there is no market for them.
So what, he should have got 50 quid for general damages?
Well, that would be an alternative, but I don't believe there was an alternative claim for general damages put here. But the court could say, well, there is a loss of use here, but it is wrong to equate loss of a vehicle with an MOT with a vehicle without an MOT, to say that they are the same thing and justify the same level of compensation is wrong in principle. And the court could say, so we say it wasn't reasonable to hire, we step back and we award general damages, and that's a jury award, and at that point the court, it used to be £10–15 a day, but that was people who had legally usable vehicles, and I don't know whether that figure's gone up, but there aren't many claims for loss of use on a daily rate basis these days because most people are persuaded to take a credit hire vehicle in no-fault accident situations. But that certainly is one way of squaring the circle. If you look at it as...
Persuaded by the defendant's insurers to take the car. You said there aren't many claims for credit hire claims now.
No,
because
sorry.
The claimant's persuaded to take a car.
No, not many claims for loss of use and inconvenience on a daily rate basis. My lord,
Because
the credit hire market is such, and insurers offering courtesy vehicles, that most people involved in a no-fault accident will have a car from one source or another. I'm talking about the situation perhaps 30 years ago. Your lordship may recall from earlier involvement, there's reference to the level in some of the appellate cases where people would not hire because there wasn't a developed hire market at that point. And county courts would be in the habit of asking, how did you get to work? I got the bus. Did you have to change buses? How onerous was the journey? And then making an award of general damages based upon an assessment of the level of inconvenience. And it tended to be £10 to £15 a day. And I think there's reference to that. It's either in Lagden or Dimmond. I think it's Lagden. But it's Lagden. But that was then. And
then the credit hire market developed.
yes, so general damages claims are rare. They tend to be, if advanced, a fallback where there is a difficulty with the special damage claim. So it's a second layer of argument, effectively.
Sorry, I probably took you off.
No, you
course.
took me into the realms of credit hire claims generally. So this is special damages, but if the court were to say you can't equate a vehicle with an MOT with a vehicle without an MOT, and so it was not reasonable to hire in mitigation of loss, then there would still be the option for the court to say, but nevertheless, looking at the inconvenience sustained by being deprived of the ability to continue driving illegally, there should be an award. Now that would be a matter for a county court judge as to what they thought would adequately compensate someone for no longer being able to use their car which shouldn't have been on the road in the first place.
If we accepted your general approach, which is there's a difference in kind between the claimant's car and hiring a properly MOT'd car. But we did not accept the causation basis of your argument that there's no loss. You would lose on the matter of principle. But what should we do? Would you be submitting that we should then remit to the county court for an assessment of inconvenience,
Of general damages.
general damages?
Nei-
Or
neither
for
of-
consideration of the question whether it was reasonable to hire a car in those circumstances?
Yes, but the recorder actually found that it wasn't reasonable mitigation of loss, but of course that finding was secondary upon his finding that there was no loss. I accept if you change that basis, that question would, in theory, need to be
But
revisited.
furthermore, subject to the causation defence, he held that it was reasonable.
Yes, but he also held that it was a failure to mitigate loss. The question of whether or not it would have been reasonable if the court said that, notwithstanding the diminished state of the vehicle due to its lack of MOT, it was there was still a loss of use, then the court would need to consider the reasonableness of steps taken in mitigation of loss. And that wasn't done below because of the first finding. There was no loss.
Mr. Turner, this is as neutral a question as you're going to get. If we go back to the particulars of claim, they're at tab 18.
Sorry, what page is that?
It's page 180 and 181.
Thank you.
It
Yes.
begins with the pleading that the claim was the owner and in possession control of a Volvo. And then when we go to see the pleading as to loss, you've got it?
I'm on page 180.
Yeah,
Yes,
and if
ma'am.
you go to 181, by reason of the matters of, forgive me, I don't mean this in a pejorative way, it's a standard pleading, Mr. Turner. By reason of matters aforesaid, the claimant has suffered loss and damage, loss of use and inconvenience. And then we've got the claim for damages, we've got that. And then 5. Is there anything you want to say about that pleading? And this really is neutral. It's just the way you've developed your argument. I was just seeking to understand.
I can comment on it if that's what your ladyship would.
No, I'm simply seeking to understand, because you've clarified the way in which you're putting your case, the emphasis is on the chattel rather than the individual. Got that. Is there anything in para 5 which assists or detracts from your argument?
What I'd say in relation to that is if it effectively recognises that need is a subsequent step to loss of use. So it is averred that the claimant, having been deprived of his own chattel, needed alternative transport. So you need that deprivation before you get to the question of need, and that's the point I've been making, that we look at that first stage before we get to that question of was it reasonable to hire a substitute vehicle. Well, Lady, is there anything else you'd wish me to address
All right,
on the
I just wanted
particulars?
just to ensure that, going back to the original pleading,
Did the defence address that part of the particulars of claim? Mr. Turner. Specifically, as my lady has pointed out, paragraphs 5 and 6, the claimant for the period of hire claim needed the replacement vehicle, which is what you're saying. This is concentrating on chattel and replacement. You're saying it's not like for like. Like, I don't know where the defence is in the bundle.
it's
What's
page
it say?
167 and 68.
167. Thank you.
1689.
Need is dealt with at paragraphs 12 and 13.
Yes, which raises it particularly.
Can we show 11 as well?
And this is about other vehicles being owned. Doesn't refer to no MOT, does it?
There's 11.
11, thank you. Oh, thank you. Yes, that's the extirpe cause, though.
Yes,
It's
well,
not
this
on
was
the causation, is it?
this was the argument at trial
As to whether or not you
as
could
to whether
argue
or not
it.
the
Yeah,
pleadings were wide enough.
yeah, sorry, and you have said that.
Yes, so the pleadings aren't perfect. They are perhaps boilerplate, might be the expression to an extent, county court pleadings.
Standard was my gentle term.
Your ladyship. So we have the pleadings as they are, and then we must look at what the trial judge did permit and didn't permit for the recorder. And the recorder actually was very judicious in that regard, in that he didn't allow an argument which he thought was one step too far,
Which was the
which
fronting.
was the fronting,
Yeah.
which frankly would have disposed of the claim on the recorder's findings. But he did allow the causation argument on the basis that, well, causation is effectively a general issue that the claimant must plead and prove. And so he'll allow argument in relation to causation. But there was no specific causation pleading in relation to the MOT.
And that wasn't appealed before
That was
Mr.
not
Justice
appealed.
Martin Spencer.
No.
Does the defence does not as such say there is no loss caused? But it's water under the bridge now, because that is the issue that both the recorder and the judge decided, and we've got to deal with.
There was a denial, a bare denial at paragraph 7, following a paragraph 6 just above. This is on page 168. An allegation of failure to mitigate loss.
Yes, but it's failure to mitigate their loss, which suggests an acceptance that there was a loss, in that they hired a car when it was unnecessary.
Yeah.
I mean, okay, this is boilerplate, but it's meant to cover everything.
My lord, there wouldn't have been pages of argument at trial about the state of the pleadings and whether or not the causation point could be argued if I could now point to a point within the defence where it was clearly set out. It wasn't, but a decision was taken by the recorder at trial, at fast-track trial, that the allegation is such that it comes within causation generally, and so argument was permitted.
So we're not on a pleadings point. That's what you're telling us.
Hopefully not,
Yeah,
my lady.
we're not on a pleadings point. Yeah, we've got that
This
message.
is not a hill I would choose to die on, shall we say.
Yeah, okay.
Now, in terms, I should drill actually with the ball tyre comparison.
Yeah.
I say MOT more significant because of threshold requirements, etc., the effect it can have on insurance. I've made those points. But I have to concede that this may not be a bright line issue of illegality, no loss. There may be cases where a judge would take a view that the usability of the article had not been diminished to such an extent that it was valueless.
Can I just get this? There may be cases where a judge would accept that. Where do we go from there?
Accept that the article had not been, the usability of the article had not been diminished to such an extent that it became valueless. And examples there, bonnet mascot, the wrong font on your number plate. County Court judges, in my submission, should be trusted to well recognise arguments which are the wrong side of the line.
Baltar, which side?
I haven't had a case with the bonnet mascot or the wrong number plate font, but if I were to express a view from the bar, I would say that most judges in the county court would probably say that would not invalidate claim for loss of use.
Okay, but I'm going to ask you, should it? And if
My
not, and
opinion
if
as
not,
an
why not?
advocate.
No, it's important. I'm not being flippant, because if we're going to try and provide a principled response to this issue, we need to understand where it goes at the edges. And at the moment, it seems to me that one of the edges is MOT Baltar. I accept what you say about font on number plates and things like that. Baltar?
Again, it's a question of degree, a matter for the individual judge. Let's say we have a tyre which is 1.x millimetres of tread as opposed to 1.y millimetres of tread, so it is marginally below the legal threshold, so there is an offence of having a bald tyre. But in another case, you might have a tyre where it is down to the webbing, threadbare. So obviously, in that case, a judge might say, this tyre was such that it was illegal for this car to be on the road. There's no indication you were going to change your tyres. You haven't produced any evidence of that. And so your car was already not legally usable because of the seriousness of that defect. And so we get back to the diminished quality of the article is past the threshold. And so we get back to causation, no loss. Or alternatively, unreasonable decision to hire to replace that seriously defective vehicle with a credit hire option or any hire option.
Or alternatively, last alternative, you use the flexible mechanism of extirpation.
My lord, that option would be available, but it doesn't take away from the fact that the causation alternative is also there. And it should be open to a judge to say, do I really think here that this article's usability was taken away by the accident, or had it been taken away prior to the accident already by that seriously bald tyre?
And if it's causation that's in front of the judge being argued, the judge then, you say, isn't obliged to consider the proportionality, step 3 of extorpy, Patel, step 3, because it is a totally different animal.
Yes.
And that's what you say, effectively, although you delicately wonder at some of Mr. Justice Martin Spencer's paragraphs, that the judge was entitled to do that. However he expressed himself, that's what he was doing.
Yes.
Do you want to tell us, is perhaps after the short adjournment now, and I don't mean to embarrass you, to tell us why you use the phrase that you did about the muddying of the analytical waters, or have you already explained that?
I haven't, but I can do it shortly if we go to the judgment.
Do you want to do it after the short adjournment? Because we're not going to finish the case, are we, even if we sit on? Because we've got to hear from Mr. Williams about some of your points.
Yes.
So would it be convenient to come back at 2 and tell us?
Yes.
Thank you. Is 2 o'clock all right for you too, Mr.
Certainly,
Williams?
my lady, thank you.
Thank you.
Just to let the court know that the recording is still going, it's a 90-second delay, so anything you want to discuss that you don't want on the stream,
Thank you.
keep outside.
So is that not reliable?
For 90 seconds, no.
Okay,
So
good
it
to
will
know.
still
Good to
be
know.
streamed.
Thank you.
And I'll be locking the court over lunch, so you can leave your phones. Of course, yeah.
I'm guessing we're in the closing furlong there, are we?
I think. Oh,
Yeah.
sorry, Ben.
Yeah, I was getting the
do you want
impression
more?
that you were actually quite keen to wrap up.
Yeah,
I was just seeing if my impression was right, just in terms
Yeah,
of telling-
there's
yeah.
Hewison to deal with. but I-
Exactly. Yeah. Oh no, I wasn't trying to hurry you, Stephen. I was just general, just an inquiry.
Yes, yes. Thank you very much.
Thank you. See you later.
See you later.
Thank you.
Thank you very much.
Thank you. Yes.